I'd like you to explain to the listeners what a regulatory taking is.
So what if you have a regulation that simply forbids you from making use of your property, economic use? And so I talk about examples in my case where people wanted to develop their land to build a house or something else, and they're not allowed to do so. And the idea is that if a regulation, it can have the same effect on property as if the government builds a highway across your property. You can't use it. You can look at it, but you can't use it for any economic purpose. It has essentially been taken by government for environmental amenities, to keep open space, to keep an agricultural preserve area in agriculture, all kinds of things that destroy economically viable use. And since the 1920s, there's a famous Supreme Court case where the Supreme Court said, look, if a regulation goes too far, it is a taking. And there's actually all kinds of history back in the 19th century as well, where regulations that were so severe on the use of property, government was found to have acted unconstitutionally. And so one of the things I talk about in the book is that if we are regulating property too severely for environmental, open space, any kind of preservation or habitat conservation, essentially the landowner is being forced to pay for a public amenity.